Hello, everybody. Welcome to the live stream. My name is Bradley Chaplick, and I am a condominium lawyer at Horlick, Levitt, Lella. I have been a condominium lawyer for more than 11 years, and we're here today to answer your questions live. You can ask us anything you wish. A lot of the questions that we've been dealing with for the past 7 weeks that we've been doing this have to do with the state of emergency, but your questions do not have to deal with that topic. We can talk about anything you guys want to. And I also have some things that I want to talk about. Maybe they'll get asked as questions, but if not, if you're not already subscribed to our YouTube channel, you can click below, I think, something like that. And then you can be subscribed. And that way you will be notified if you click the bell of future videos. So just to give you an idea of what we're doing to try and stay connected, every Monday on our email list, we release a updated frequently asked questions pertaining to the state of emergency. And we'll keep doing that as long as there is a state of emergency to report on. And then we do this live stream every Wednesday at 12 noon. And on Fridays, we're releasing case law corner videos, updating you on new case law from 2020. And if we run out of interesting cases from 2020, we might go back to 2019 or even talk about some of the most important condominium decisions that we think every condominium manager and every director should know about, because they are really important to how we do things. So haven't got any questions in yet, please put your questions in the chat. You have to be logged in to use the chat. So try and do that. And then we will start answering your questions. But in the meantime, we had a question come in through our fan mail. And the question was about a condominium corporation where the board of directors had authorized a construction project, and I'm not going to say the exact same factual scenario that we got in the email, but I'll describe a similar scenario. But basically, the board of directors had authorized some work to be done in the condominium property that was not urgent. It was not an emergency repair, and the work was not. The manager didn't know about it. So the manager was worried that he would have liability arising from this work because of the emergency order closing non-essential workplaces. And the fines are very high. So for an individual, the fine is up to $100,000. For a director of a corporation, which in my view includes a condominium corporation, the fine is up to $500,000. And for a corporation, it's up to $10 million. And there's also the possibility of a term of imprisonment of up to 1 year. Now, I don't think anyone would be facing imprisonment or a fine on a first offense of $100,000 because you started a construction project in your condominium. But if it was a repeat offense or if something really serious happened, it is certainly possible that you could face a significant fine. So the manager wanted to know what was his liability in that he was not the person responsible for having allowed the work to begin. The board had sort of acted on its own without his knowledge. And you can imagine that this might happen if you are a person who manages many condominium buildings, but you're not on site because maybe you have a portfolio of 5 or 6 buildings that you manage, right, part-time. And so the answer, what the manager wanted to know was, would it be enough for him to basically, send a letter to the board saying that this was done without his knowledge, and he suggests that it stop. And in my view, just simply writing a letter would not be enough to avoid liability. And because of that, the explanation for that has to do with regulatory offenses. So regulatory offenses have a special test for liability. And it's a 2-part test. And so the first thing that would happen if you were to ever, be faced with prosecution is that the representative for the government, the Crown Attorney in this case, would have to prove beyond a reasonable doubt that the prohibited thing had happened, i.e. that the construction work was taking place contrary to the emergency order. Okay. Then the burden of proof shifts onto the person who is being accused or being, facing the fine, and you would have to prove due diligence, i.e. that you took all reasonable steps to avoid liability, and that would depend on expert evidence as to what are the steps that a reasonable property manager would take in this situation. So the question is, would a reasonable property manager stop after writing an email or a letter and not take any further steps if the work was still continuing? And I would say that no, a reasonable property manager would continue to take escalating action until the circumstance was brought back into a lawful state of being lawful, i.e. the work had stopped. And so if this happens to you and you're a property manager and something happens on your property that's not lawful, it's not good enough just to write one email. You've got to continue to take action until the problem is solved. And in my view, that means escalating action. It might mean, reporting things up the chain at your management company and seeking assistance. If you're the head of the management company, it might mean, insisting on speaking directly to the board, president of the board, whatever you can do to encourage the board to comply, and you have to persist until compliance is reached. And if you could prove that you were doing that, then you would not be liable, but you would have to take those steps. That's my, quick view on regulatory offenses and liability and what a reasonable property manager would do in those circumstances. So thank you for the question, came in via email. And now we've got some questions coming in through the chat. So let's get to some of those. Paulette asks, if the city reopens, does a board have to follow suit, opening up their amenities? This is a great question. So I would say that you are not required as a condominium corporation to open up at the same time that the city does. And there's good precedent for this. And the example is a case called YCC 419 in Black, which is a recent decision where a condominium corporation had decided that they would not permit non-essential renovations from continuing, even though under the current emergency order that is allowed. And so the condominium corporation's rule for its property was more strict than the provincial order, and the court seemed to support that, and a emergency order was granted in favor of the condominium corporation stopping the renovation. So in my view, condominium corporations can have rules that are more strict than provincial law. And of course, we all know that from other examples of condominium rules. So for example, some condominium buildings are smoke-free, and there's no provincial law that says that your building has to be smoke-free. So condominium corporations can have stricter policies and stricter rules than what the province would allow, but your rules and policies must be reasonable. And so you would have to think about, if the city reopens or if the provincial state of emergency is lifted, at that point, what is a reasonable restriction to place on your amenities? And it might, it'll depend on your property and what kind of amenities you have to come up with something that's reasonable. So good question. Thank you very much. I think you can be stricter. Bob, if we postpone our AGM for a year, as has been suggested as a possible option, does the current board remain until the 2021 AGM has taken place? This is an excellent question, Bob. Thank you. So as a general rule, the board's term of office does not expire until you actually hold the AGM. So a 3-year term does not mean that it expires. If you're supposed to hold your annual general meeting by June 30th, 2020, it doesn't mean that their term expires on June 30th, 2020, whether you have a meeting or not, and now you have a vacancy. The term continues until you hold that election. So the short answer to your question is that the board does remain in place. And just some more background to your question is I hope we don't have to postpone AGMs for an entire year. There is a time limit by which you have to have your AGM after the state of emergency ends. So if the state of emergency were to end, let's say July 30th, and you were supposed to have your AGM by June 30th because you had a December 31st year end, so 6 months takes you to June 30th. And so now there's this emergency order which says you don't have to have your AGM during the state of emergency, but let's say the state of emergency ends July 31st or whatever. You now have 90 days to hold your AGM. So that means August, September, October 31st. So you got to have your AGM by Halloween, and that's your 2020 AGM. So I think that's a pretty realistic scenario, is that we're going to be having a lot of AGMs, 2020 AGMs in the fall, and hopefully not in 2021. That's what I hope. Bob, I'll follow up. Also, what happens to the terms of the director up for election in 2020? So this is still under the presumption that you have 2 years meetings at the same time, which I think is unlikely, but it's possible. If you were to have 2 years meetings at the same time, you could do it in 2 different ways. You could have back-to-back meetings, or you could have one meeting at which you present 2 sets of financial statements and have all your directors elected all at once. And let's say you did that and you combine the meetings and you presented 2 years worth of financial statements and you had all the directors elected. So maybe you could even have 4 out of 5 directors, for example, elected. You would have 2 of them for 3-year terms, 2 of them for 2-year terms, and that way you would keep your stagger. So and I would generally suggest, unless your bylaws say otherwise, that the people who get the most votes get the longest term of office. That's typically the way it's done. So you keep your stagger in terms of the terms, but unlikely that we're going to have to postpone AGMs all the way to 2021. I hope not. Lana, Ford has reopened garden centers and landscaping. Does this mean we can have irrigation opened and landscapers begin work if social distancing is practiced? Great question. Yes. Yes. So the question, just so everyone understands, is as of May 4th, that's this Monday, the list of essential businesses was amended to include a bunch of seasonal businesses. Most importantly for condominium buildings is lawn care and landscaping is now considered an essential business. So they can open, they can do work. So all your landscapers can come on site as of 2 days ago, and they can do their spring cleanups, and they can plant flowers, and all that stuff can happen, and they can turn on your irrigation. All of that can happen. That's all good to go now. So in April, we were getting a lot of questions about landscapers not being on the job, and what do we do? Do we have to still pay them? And we were talking about force majeure clauses and contracts, and that is now essentially resolved, because all the work that they were supposed to do in April for a spring cleanup, they can now do it in May. It hasn't been postponed that long. I think the work can still be done, and those contracts can be fulfilled. So that was a helpful solution to what would have otherwise been a very difficult legal problem for a lot of condos. So yeah, landscaping's a go. Debbie, does the easing of construction work include owners' in-suite renovations that began prior to government restrictions? Okay, so I'll clarify this. The emergency order closing non-essential businesses or workplaces had an exception put into it on April 3rd that said if you had an in-progress residential renovation as of where work had started before April 4th, you could continue and complete that renovation. So that has been the law now for more than a month. So there is no provincial order preventing those renovations from being completed. But some condominium corporations have put in policies that are stricter than the government's order, saying we don't want to have multiple renovations, and you can think of at least one really good reason, which is people are home all day, and so the noise is going to be a problem. And so for that reason, among many other reasons, some condominium corporations have said we don't want disturbing renovations taking place because people are home all day. All this stuff, even though it's not illegal as per an emergency order, it should all wait. And that type of restriction was upheld by the court in the YCC 419 and Bilat case. And that was one of the things I want to talk about was landscaping. So thank you for bringing it up. I'm going to cross it off my list of things to talk about. So yeah, so that's, I think, the answer to your question, Debbie. Paulette, when the facilities amenities are reopened, so going back to the amenities question, should the board then impose a higher level of cleaning, security to limit the number of people, seating space to ensure physical distancing, etc.? I think that's a great suggestion, Paulette. So the idea here is if you reopen your amenities because the state of emergency is over, so let's say, we're in August or September or something, and we're no longer in a state of emergency, and COVID in the community is relatively rare, and you want to open up your gym, would you still have enhanced cleaning in the gym? Would you take out some of the equipment so that the pieces are further, like maybe each treadmill is at least 2 meters away from the one next to it? And that you remove some stuff to have, again, reduce the number of people that are allowed in the same time. These are all excellent suggestions, and I think that is a great way to do it. And then you can put the rest of the equipment back in when it appears safe to do so. So that's a really excellent suggestion, Paulette. I hope you don't mind. I'm going to take that and use that if people are asking me that question. So thank you. Ramina, hello. I was wondering about reserve fund contributions. It has been noted that a corporation can decide to reduce their current year contribution amount, but I've been asked by several clients. What do you mean? What do you mean, Ramina? I think something we were talking about early on was that you could postpone putting the money into the reserve fund bank account to leave yourself some operating room if owners were defaulting on their monthly common expenses. So I'm not sure how much of a problem that really became. I mean, I can say that we did not notice a huge spike in April liens, for example, but that could be because people have been managing it internally with their owners. So I would say that idea is still in place. But if you have more questions about reserve fund contributions, it's going to depend on your reserve fund study and what you need the money for. But we've suggested to people that once you put the money in the reserve fund, it has to be used for those proper reserve fund purposes. And if you have a operational cash flow problem, that perhaps postponing putting the money in until later in the year was a quick and easy way to prevent your condominium corporation from running out of money in the short term, but you would eventually have to put the money in. So I hope that answers your question. Diane, our AGM was postponed due to COVID. We are considering changing the year end to match the sister corporation from September to April 30th. Should this be considered, and what is required for this change? Okay, so changing your year end. Condominium corporations do this from time to time. There's a few steps you have to take. I might not get 100% of them just off the top of my head, but for sure you're going to have to check your bylaws and see if it can be changed by board resolution. Often it can. Then you're going to have to talk to your auditor, and you're going to have to do a partial year financial statement. And so you're going to have a year that goes from September 30th to April 30th. And then you'll have a new April 30th year end regularly after that. So that probably also involves filling out a form and sending it to the government that your auditor will be able to help you with, that just updates them on your fiscal year end because you have to file a notice with your advising the government of your financial year end. So basically you fill out a form, you pass a resolution, you're going to have a short year, and you're going to have a one set of financial statements that doesn't cover a full year. You're going to have to also jig around your budget a little bit. It might affect your reserve fund study, but these are all manageable things. Condominium corporations do change their year ends all the time. It's not something you should do every few years, but if you have to do it to put yourself in sync with a sister corporation so that your shared facilities budget and all these things come out at the same time, it seems like a really reasonable thing to do. And it's a bit of a schlep in the first year that you do it, and then after that, it makes your life easier. So it's definitely worth doing, and I think you should do it. Murray, the CDC and WHO are suggesting that social and physical distancing should continue until there is a vaccine. I have no reason to disagree with that, Murray. I think you're perhaps referring to the suggestion that amenities would open up with physical distancing measures in place and enhanced cleaning, and that could continue until such time as there is a vaccine for COVID. And I think that is reasonable. Agree. Once again, Murray and I agree on yet another topic, as is frequent in these videos. MTCC 1395, landscaping work is allowed even if the workers have to go inside the suites, ? Our corporation landscaping work is on all the exclusive use common elements. Okay, I see what you're saying. So this is a condominium corporation where the landscaping is accessed through the units onto terraces. And the answer to your question is that yes, the work is allowed to proceed, meaning that it's not prohibited by law. How you arrange for that to happen is going to be specific to your corporation. And we do have other condominium corporations that are doing emergency work, for example, inside of units, and the people just wear masks and gloves and they go in and they do the work, and it can be done. So I think in your case, you would have to put in appropriate safety measures, and then you would obviously give notice to people. And if residents didn't want contractors going through their units, that's understandable. You might want to make accommodations for people. But if everyone's okay with it, then you can do it. Because the work is actually being done outside. You're just transiting through the units. Okay, Romina, about extending the contribution phasing beyond industry accepted 3 years. Are there general guidelines on this in light of COVID, or should they seek an independent opinion from their solicitor? You need to do this is a question about reserve fund studies. You need to do your reserve fund study, a full study or an update every 3 years. So you cannot take a current reserve fund study and then just extend it without doing a new one. I hope that answers your question. Get your reserve fund study updated. If you've had to delay your study because of COVID, that's understandable, and you're just going to continue with your existing studies recommendations, and then get your 3-year update or your 3-year full study done as soon as you can. I hope that answers your question. But if your details of it are more specific than that, and you need an opinion from the condominium corporation's lawyer, then yeah, I get that opinion. But update your reserve fund study as soon as you can, if you're talking about extending it past 3 years. Danielle, hi. We currently do not allow showings. We're talking about real estate showings now. However, I'm getting pushback from owners. Realtor showings by appointment are still considered non-essential, correct? Okay, not exactly correct. The banned activity when it comes to real estate showings is open houses. So open houses are prohibited under the closure of non-essential places of work. Showings are permitted, but RICO and TREB and AREA and all of the governing bodies dealing with realtors in the Greater Toronto Area and across Ontario say that you should not be doing in-person showings unless it is absolutely necessary. So the professional guidelines for realtors are basically to do virtual showings and to only do an in-person showing if it's necessary. And the classic example that comes to mind is that you have someone who has put in a offer based on a virtual showing, and then that offer has been accepted and it is conditional on an inspection by the prospective purchaser. And then if that's the case, if you've got an agreement to buy the property subject to an inspection, then you would allow the purchaser to do an inspection. That should always be allowed. But condominium corporations can have policies saying we're not going to allow showings generally in general because it's unnecessary and it puts people at risk. And often you would have, if you have multiple units, for example, for sale in a given building, you would have realtors come in and show multiple units in the same building just for comparison. And you have all sorts of unnecessary activity in the building. So condominium corporations can say that's not allowed. And owners can push back, I suppose. But the fact is that it's very reasonable to restrict the number of showings to only those that are absolutely necessary. So Danielle, I think you can keep those policies in place for the time being. And the realtors and the owners who are objecting and saying I should be allowed to show my property are not behaving in a manner that is consistent with the professional guidelines for realtors. And you can look on RICO's website and you can check our FAQ, and we have the citation that takes you to that website that shows you that people who regulate realtors say you shouldn't be doing this. Okay. Terrion. So Terrion extended performance audit submission deadlines for corporations under their coverage. What about common element condos whose deadlines remain based on their registration date? So this is a question about extension of Terrion deadlines. Terrion submitted a bulletin that explained the extension of deadlines. I'm sorry, I don't have that bulletin committed to memory, but there are two bulletins. One has to do with deadlines to submit your performance audit, and the other one has to do with the deadline to do pre-delivery inspections of properties. So there's two Terrion bulletins. They're available on Terrion's website. So you can go onto Terrion's website and have like a COVID page, like landing page, and you can click on there and you can see there's a bulletin from I think late March, and there's another one from April, and read the earlier bulletin, and I think it will answer your question, Romina, about what to do about your performance audit submission deadline. And you can check if there is an extension for that. I believe there is, but please check the bulletin on Terrion's website. Your engineers will know. So ask your engineers for the exact deadline. Miriam, is there any bylaw called maintenance bylaw? My board member is asking, and I have never heard about it. I've also never heard about a maintenance bylaw. What would be in it? Maintenance is not something that would typically be in a bylaw. Bylaws, this is a question about what are the sort of what's the typical subject matter of bylaws. You can check your bylaws. You can search title and you can pull all the bylaws and read them. And I think you should if you're not sure what's in the bylaws. And but you're saying, could someone pass a maintenance bylaw perhaps? Like if you don't have one, can we get a maintenance bylaw? I don't think that you would. No, but you could pass policies and things like that as to what you would want to do for maintenance. I don't know. No maintenance bylaws, not that I'm aware of. Bylaws are about governance of the condominium. They control the activities primarily of the board of directors. So maintenance bylaw would not be typical. Jerry, Brian has provided some information on how to initiate and pass a bylaw to permit electronic balloting. Can you clarify the procedure required in light of COVID-19 restrictions? Yes, I can, Jerry. So this was also on my list of things to talk about. And let's talk about it. So right now, there is an emergency order amending the Condominium Act that allows each condominium corporation without an electronic meetings bylaw, to hold an electronic meeting during the state of emergency. So typically you require a bylaw. Right now you don't. You can have an electronic meeting, but only during the state of emergency. So you might want to pass, and we think most condominium corporations should want to pass, an electronic meetings bylaw that would allow you to continue to hold electronic meetings after the state of emergency is over, which would give you more time for future needs to engage in social distancing, which might continue for a year or 2 years, or perhaps even longer. So thinking about the future, you want to pass one of these bylaws. How would you do it? Well, right now you could do it by holding an electronic meeting, because you don't need a bylaw at this moment. So if you want to act on it now, I would suggest the timing is right to hold an electronic meeting of owners, during which you would pass an electronic meetings bylaw that would allow you to then continue to hold electronic meetings even after the state of emergency is over. And then more specifically, the voting threshold to pass a electronic meetings bylaw is not the same as a traditional bylaw. A traditional bylaw, the threshold is a majority of the owners of all of the units in the corporation, all of the voting units. So if you had 200 voting units, let's say residential units in your condominium, then you would need 101 votes in favor to pass a traditional bylaw. But under the low threshold bylaws, which include electronic meetings, you only need the majority of those present at the meeting. So this means if you have, again, your 200 unit condominium, your quorum for a meeting of owners is 1/4, so that's 50. And then you would only need a majority of those present. So let's say you achieve minimum quorum is 50 people, 26 yeses votes in favor passes your electronic meetings bylaw, which is a lot easier to achieve than 101. So hope that explanation helps. And if you need an electronic meetings bylaw, you can let us know, and we have them for you, and we can get them out the door really quick. So we encourage people to do that. We think it's a good idea. What advice would you recommend boards who are contemplating cutting all lockboxes to minimize Airbnb and COVID-19 socializing activities that could go on? You want to cut lockboxes on the property. You would have to do it with proper notice to people. So I think what you would want to do is you would want to send a notice to all owners saying that lockboxes are not allowed to be left on the common elements, and asking them to be removed within a certain period of time, failing which they will be cut and removed, and the contents will be appropriately disposed of. Generally speaking, most condominium corporations do not allow people to put lockboxes like on the property without permission. The rule that I'm most familiar with is that if you have a lockbox, you have to give it to the concierge if you have one, and it's kept by the front desk, because of course you don't want these lockboxes all around the property. So I would send out a notice saying all the lockboxes on the common elements have to be removed. If they're not going to be removed by a certain date, they'll be deemed abandoned. They'll be cut and disposed of safely. So I would do that with a notice. People should not be putting lockboxes on like fences and stuff around the condominium property. It's not attractive, and it's not safe, because obviously those lockboxes have keys in them that create a security problem for the building. So don't have lockboxes like that. Give notice. Paulette, just to follow up around the amenities, is there any liability for corporations or residents' safety once they are reopened? Okay, so this is Paulette's question about opening up amenities. So we're talking about a future in which there is no longer a state of emergency, and in which it is no longer required to have amenities closed by law. And then if you open them up and someone was to contract COVID, would the corporation be liable for that? I would say that if you could demonstrate that you were taking reasonable precautions, you would not be liable. So those reasonable precautions would include regularly cleaning and inspecting and having signage and doing all the normal things that you would do to keep your amenities safe in the ordinary course. So I think I don't foresee a massive liability to condos, But I would certainly think about putting signs up saying, use at your own risk, that kind of thing, and maybe having waivers that people would sign to use the amenities when they're first reopened, acknowledging that there's an inherent risk, and all of those things will help you reduce your liability. So all good ideas about carefully reopening amenities and that people acknowledge risk. Peter, owners are asking for a reduction in monthly management fees due to closed down amenities. I think you mean monthly common expenses, not the property management fees. Due to closed down amenities, gym, pool, etc., being closed due to COVID. Your thoughts, please. My thoughts, no, you don't get a monthly reduction in your common expenses because the gym is closed, because that's not how common expenses work. Common expenses are not a club membership. It's not a fee for service. Common expenses represent the actual cost of operating the not-for-profit condominium corporation. And so you can say to those owners that perhaps there is a cost savings associated with closing the amenities, but that cost savings is also going to be offset by higher costs for doing other things like having to clean the common elements at a more frequently, and materials and labor for that, and that it all just evens out, and the budget is what it is. And then when you go into next year, you'll set a budget based upon how things turned out for the year as a whole. So I think that you could create a reasonable response to owners who are requesting a reduction in common expenses, and you can explain that they are not calculated as in, like, it's not that you pay $10 a month for the gym and $10 a month for the pool. You just pay to operate the condo, and whatever the cost of operating the condo is, that's what it is. And in any event, you were required to close those amenities. So it's not something that the corporation did because it was trying to save money. You did it because you had to for public safety. So I don't think there's no reasonable basis for reducing people's common expenses. You're just creating a deficit for the corporation that has to be made up in future years. So there's no money to do that. It doesn't exist. That's my thoughts. Diane, balcony pigeon netting was removed last year for a balcony project. Can owners have new pigeon netting installed now, as the pigeon droppings are considered a health hazard? I don't see why not. That's something that you can deal with as a policy or as a rule for your condominium corporation. And if you want to encourage people to install pigeon netting and you think that that's acceptable, then sure, yeah, go for it. Robert, given that the requirements for physical distancing and PPE will be with us for a while, this may increase reserve fund project costs by more than a minimal amount. Do you think that these expenses, especially if a corporation has many reserve fund projects planned over the next 12 to 18 months, should prompt a reserve fund study update? And are these expenses reserve fund eligible? Okay. Sorry, I just lost the chat here. Okay, there it is. So thank you for the question, Robert. First of all, anytime you do a reserve fund study update, that is a cost that can be paid for from your reserve fund. Similarly, anytime you do a reserve fund project, that cost, even if it's more than what was anticipated in the reserve fund, is paid for from the reserve fund. So to answer that question, all of those costs are proper reserve fund expenses. Should corporations do a reserve fund update because of that difference in cost? I would say no. I think it's overly cautious to do an update just for that reason. I think you should do your projects, see what the costs are, and then based upon those projects having been completed and having come in above or below budget, that's when you want to do your reserve fund study update. Much better to do the updates after you've completed the projects and you know what the actual costs were than before you've completed the projects. You're going to get a much better and more accurate reserve fund study update if you do it after your projects, not before. So that's my suggestion. Do it after. Contractor can start preparing outside pool for opening, question mark. I don't know. This is Yuli. Can a contractor start preparing the outside pool for reopening? I would say no. I don't think that was on the list of the expanded list of essential businesses. I think you're going to want to wait on that. We're not at pool season yet, so hopefully in a few weeks that will resolve itself. But in any event, your pool has to be closed. It's an outdoor recreation facility, and there is no, I didn't see anything in the emergency order. I can check it, but I didn't see anything in the emergency order allowing swimming pool spring prep work to be done. So I think it's a no on that one. Okay. Robert again. Vacant unit, okay. Waiver to be signed by buyers, tenants each day showing once they're done, provided. Okay. This is Robert's putting in the chat here about real estate showing. He's saying if it's a vacant unit, you can do showings. Waivers to be signed by buyers, tenants each day. Showings are done, provided to both brokerages. That's his practice at his brokerage. So there you go. So Robert's saying that there's some protocols in place for in-person showings. And I think those rules would be in addition to whatever the condominium corporation's own policies are. Robert, common element corporations are exempt from Tarion performance audit. Condo Act only presides over, so Robert's talking about Tarion for common element condos. Okay. Dreadbane. How about rodent removal, pest control in townhouses? Can that be considered essential? Yes. Rodent. Question is, can you do pest control? Yes. So maintenance that is necessary for the safety and sanitation of the property is a part of the essential services maintenance provision, and I would say pest control is definitely appropriate for safety and sanitation. So yes, you can do your pest control. That's allowed. Romina, common element condos are not covered by Tarion. Condo Act still requires condos to have a performance audit done within their first year. Are these condos getting similar extension by the government? Oh, I don't know the answer to this question, Romina. I'd have to look into it for you. This is a tricky question. So if we're not talking about Tarion, warranty obligations, and you're just talking about the obligation to do a performance audit within the first year, and whether that has been extended, have nothing to do with Tarion, then I'm not aware of any extension. But that said, if it's not linked to submitting the performance audit to Tarion, you're just doing the performance audit for your own negotiations with the developer. So I would say you still want to do it as soon as you can. But that the limitation period to sue the developer is extended by the suspension of limitation periods. So that does help you. So you do have a little bit of help in terms of suspension of limitation periods if you're going to sue for construction deficiencies, but try to get your performance audit done as soon as you can. Talk to your engineers. Dreadbane, additional. How should a corporation address the removal of trees, fences, etc. installed by owners at this time? They are considered violations in some corporation declarations. Okay, this is a question that's come up a bunch of times. Thank you for the question. Again, it continues to be an important question. So where unit owners have made an alteration to the common elements without what's called a Section 98 agreement, sometimes those alterations are retroactively approved, and sometimes the corporation requires that they be removed. So the question is, what do we do about this during COVID? Because it's going to be more difficult for people to arrange for things to be removed. So first of all, now that as of May 4th, landscaping and lawn care are considered essential businesses, that partially answers your question, is that the work can be done now. I would still want to give people a reasonable amount of time to complete the removal, because you have to appreciate that people are going to need a little bit more time to get things that would normally take 2 weeks. Maybe now it takes 30 days. So give people a little bit more time to comply. And if you can reach an agreement to comply by an extended deadline, that's a great idea. And if people are saying it's not a question of having extra time, they just don't want to remove the stuff, then I would refer to your lawyer and have them send a letter saying, here's why you need to remove your tree or your fence or whatever other thing that you've installed on the common elements within a certain amount of time. And if you don't, then there's legal consequences for that. So give people a reasonable amount of time, I would say, is the best thing to do. Alexandra, we don't have a restriction for smoking on balconies. If we do, how do we go about checking the balconies deemed to be used for smoking? Can we enter with a notice to check the balcony for that purpose only? Okay, so this is a question about smoking in condos. So the question is, how do we enforce these no smoking rules? So first of all, most condos work on a complaints-based enforcement system. So you would pass a rule saying you can no longer smoke on your balconies, and then you would investigate upon someone actually complaining and saying, hey, my neighbor smokes on the balcony. And you might want to see some sort of photographic proof of it. So sometimes people will just like take their cell phones and snap a picture of someone outside smoking on the balcony, and that's your good proof. That's typically what you're gonna be doing, is relying on emails, complaints, perhaps photographs of people actually smoking on the balconies. And if you don't have access to any of that kind of evidence, then I think what you're talking about is like actually going out there and looking for cigarette butts or something like that, and giving notice of entry to inspect for compliance. In my view, that's something condominium corporations can do in appropriate circumstances. I'm not sure you would do that for smoking all the time, but if you had to go into a unit to check for compliance with the rules, you can do that under Section 19 of the Condominium Act. You go in with reasonable notice. To my mind, that means at a reasonable time. And it has to be notice in writing. So I would give at least 24 hours notice. That could be problematic for you because, with 24 hours notice, they might just clean up everything and then you go in and you see nothing. So I would try, if you're enforcing a smoking rule, to try and catch them red-handed with a photograph or short video. That's the best way to do it. And then also just complaints from multiple neighbors would also be sufficient. Olivia, in a vacant land condo corporation, owners own their lots surrounding their home. Owners are allowed to make exterior alterations once they obtain board approval to be continued. Exterior renovations required, such as landscaping, patio extension, concrete pavement, etc. Can we allow just the landscaping for now and wait for other repairs to be allowed? Okay, yeah, so this is a question about vacant land condominium corporations, and it would also apply perhaps to common element condominium corporations, and saying, can we say to people, just do your landscaping for now and forget about your other renovation work? I think that's correct, Olivia. I think that's consistent with the current emergency order, which is that people can do their landscaping, people can do their lawn care, but people cannot do new residential renovation projects. They're generally speaking prohibited as of April 4th. You can continue an existing renovation, but you can't start a new one. So Olivia is now saying, will there be any liability for the condo if we allow them to pursue it? Well, you can't allow them to pursue it. You don't have that authority because it's prohibited by emergency order. So you're not going to allow people to do, patio extensions right now because it's not legal to do a patio extension right now. So you're not going to tell people that they're allowed to do it. And so therefore there's not going to be any liability for you in allowing them to do it. You're going to say no. Wait for the order to be lifted. Jerry, follow-up question. On what basis core determined electronic proxies received? ? That's actually in, so this is, okay, we're going back, reminding everyone we're talking about electronic meetings and how do you determine quorum. The emergency order says that a person is deemed, first of all, if you have a proxy, that person is present by proxy. So that's one way to do it. The other way to do it is in an electronic meeting, communications link to the meeting, they are deemed to be present for the purposes of quorum. Or if they vote electronically on any matter that comes before the meeting, they're also deemed to be present. So the emergency order itself has a provision that specifically deals with how you count people for quorum, and it's electronic proxies, of course, or else establishing a communications link to an electronic meeting if you're hosting it on a third-party teleconference or video conference software system. So, Jerry, the fine people in the government of Ontario have thought of this, and they did include it in their emergency order. We've been going for 50 minutes. Wow, guys, you've been keeping me busy here. Time flies. Let's see if we can answer some questions a little more quickly, and then we'll try to wrap up in the next 5 minutes or so. And before we do wrap up, I'll just remind you all to keep an eye out this Friday for our second edition of Case Law Corner. We're going to post another video case law review with an article as well, which will go up by email. So hopefully you can all look forward to that. So a few more questions. I'm going to try and answer them a little faster. Sherwood, private water discharge reporting and chemical tests as per sewer bylaw 681. There are 2 tables regarding chemical tests. The city does not provide any details except the bylaw. Any suggestions? Oh my goodness, please send me an email. I do not have sewer bylaw 681 committed to memory. It's something I would have to take a look at. I'm sorry, I just don't know. I don't know what your question is, but if I take a look at the bylaw, send me an email, bchaplick@hldlawyers.com. I'd be happy to take a quick review and see if we can figure out what the uncertainty is. Should be able to do it, but not now, not live. Too much. Okay. Does the Condominium Corporation put on notice board if someone is infected by COVID? This is from Vishal. This question's come up before. Thank you for asking again. The condominium manager or board of directors, we believe are not being notified by public health if there's a resident of the building who has tested positive for COVID. They would only notify you for contact tracing purposes if they believe that a person who's been infected has had close contact with someone who was an employee of the corporation. So we have said and continue to say to our condominium clients that if you become aware of a confirmed case from a reliable source and you want to post a notice in the building, that is fine. And as long as it's anonymous, we don't have a problem with that. We think that most other residents would feel that they had a right to know. And I don't think you're violating anyone's privacy as long as the information about the person, there's no information about the person, just the fact that someone in the building. So all of that information, who's coming in here? All of that information would be kept confidential, and we don't think there's any problem with that. So we think you can post the notice. Thank you. Let's go to the next question. I got a little distracted there. Gary, can a bylaw be approved using electronic voting? If so, do we need 25% of the units within the building to vote to pass the bylaw? It depends what kind of bylaw. So Gary's question is about electronic meetings. Yes, you can have an electronic meeting. Yes, you can pass bylaws at your electronic meetings. The voting threshold will depend on the type of bylaw. So a low threshold bylaw like electronic meetings would only require the majority of those present at the meeting with a 25% quorum. Traditional bylaws, you're still talking about a majority of all of the voting units in the corporation. So the threshold to pass bylaws has not changed, but you can do it by electronic meetings, Gary. Jerry, in the event an AGM is combined with another or held immediately after another, how is the appointment of the auditor for the first AGM effective? So an auditor, this is a question about if your meeting gets delayed all the way till next year, how does this affect your auditor? You would only appoint the auditor for the financial statements that have not yet been completed. So if you have a combined 2020-2021 AGM, then the auditor will have completed the 2019 and 2020 financial statements, and at the 2021 AGM, you're appointing the auditor only to do the 2021 financial statements for next year's meeting. So you just appoint the auditor once at the end of the second meeting. Answer your question. Marty, our building has balconies that are exclusive use, common element, and owner has a refrigerator on the balcony. Can we force him to remove the refrigerator? It looks unsightly. Check your rules, Marty. I can help you look at the rules. I think I know which building this is. But yes, you check your rules, and your rules will typically say something like that the balconies are only to be used for seasonal furniture and not for other kinds of storage. And then based on that rule, you would require the person to comply with the rule by removing the refrigerator. If your rules don't prohibit people from putting refrigerators on balconies, then you should pass a rule saying that people have to use the balconies properly. But check your rules. It should already be in there. Paulette, thank you, Brad. Information has been awesome. Please keep safe. Thank you, Paulette. You too. I really appreciate your questions. Let's see if we can fly through to the end here. Andrea, what are your thoughts on electronic voting when demographics of building are more mature residents? So like people who might not be as comfortable with technology, I think is what you're suggesting. I don't think that older residents would necessarily have difficulty with electronic voting. I don't think it's any more complicated than using email. So I don't have a problem with it. I think the more difficult question, Andrea, is not the more mature residential crowd, but rather people who don't have access to computers. And what do you do about people who don't have internet at home and who don't have computers? And how are they included in a electronic meeting of owners? So that's the bigger question for me, is people and access to technology and ensuring that people have universal access to internet and all those kinds of things. That's where I would focus my concerns, more so than on people who are just not as familiar with new technologies. I think most people can use email and they can figure it out, and you can help them, and you can attach, step-by-step guides. You could have people available to assist them over the phone, to walk them through it. And I think you could make it work for the residents who aren't familiar with technology, but for people who don't have computers, that's a bigger problem. Murray, there needs to be a water discharge study that dictates the testing and reporting requirements. I think that's talking about the, thank you, Murray. That's talking about the sewer bylaw question. So that I didn't know the answer to. Thank you. Adib, thank you. Oh, you're welcome. Dreadbane, how can a corporation enforce voting eligibility, arrears more than 30 days, or candidate disclosure during electronic meetings? The same way you do it as always. So this is a question about electronic meetings. If someone is more than 30 days in arrears, then they would not be allowed they would not be allowed to log in to vote at the meeting, right? Your meeting software would have to be equipped to deal with that. And it's our understanding that certain companies are creating software for condominiums that can deal with all those things. You just give your arrears list and they're not allowed to vote. Candidate disclosure, that usually goes out with the notice of meeting package. So that can still be done. And if you have people running from the floor, then you give them the floor, click a button, they talk, and you ask them disclosure questions. So all of that can be done. You just have to make sure that your software allows for it and that your meeting packages are complete as always. Okay, a couple more. Let's just see if we can fly through here. We really got to wrap up. We've been going for like an hour. Nita, hi Brad, can the corporation obligate a building staff to stay in 14-day self-isolation? The person is being tested as a contact with a confirmed case. So this is about, I guess, sending someone home who is awaiting a test, and whether you can do that. Yes, you can send someone home who's a potential who's being tested and is waiting for a result until you get their result, until they test negative. Yes, you can send them home. The bigger question is, do you have to pay them during that period of time? And you might, but you can definitely send people home. So whether you have to pay them or not is going to depend on a bunch of factors, including employment contract and how they're employed. That's a more interesting question, but you can definitely send people home. Andy, and you should send people home because you don't want an outbreak in your workplace, right? You have to send people home so that you don't have an outbreak. It's about the safety of the other employees. Excuse me. Andy, can a resident bring in a private landscaper to work on an exclusive use common element terrace now that landscaping is allowed? Yes. If your condominium corporation allows for it, then yes. So that's allowed, and I think that's okay. And you would want that person to wear a mask and gloves through the common areas, and you would want to have a notice of it, and I think that's fine. Margarita, is the corporation allowed to take a picture of a smoking resident on the balcony? Sure, why not? I don't have a problem with that. Are you talking about privacy concerns? No, you're taking the picture for a legitimate purpose. You're not taking a picture of them in a place where they would have an expectation that they're not, that no one can see them, right? You can see them on your balcony, and you're taking the picture for the purposes of showing that they're breaking the rules. Take a photograph. I think that's totally fine. No concern. Bob, thanks, Brad, for taking the time to respond to our questions. In some cases, you are providing opinions. Can we refer to your opinion as a legal opinion in our daily dealings with owners? The opinions that I express today are not written legal opinions that you would rely upon under Section 37 of the Condominium Act. I'm answering your questions. I'm pointing you in the right direction, and I think you should seek opinions in writing. I think that's the best way to do it. And you should make sure that the person who's providing with that opinion has all of the relevant facts. Often I'm just relying on the limited information that I have. I'm not checking your declarations. I'm not checking your bylaws. So, you can certainly tell your board that you've asked the question and you got this answer, but if you're needing a formal opinion, you should get one. This is about sending an employee home. You said the live-in super. Yeah, so this is a question about can you require the live-in super to be in isolation? Okay, so this is a little trickier. Your live-in super is being tested, and the question is, should they be allowed out of their unit while they're awaiting their test results? I think most public health authorities would say that they should not be allowed out of the unit while they're awaiting test results. And that's something that you will want to talk to public health about and talk to the super about. And you would strongly encourage that person to remain inside because you don't want the super in the common elements if the super is awaiting a test result. So yeah, Anita, you're going to want to explain to your super that he or she needs to remain in the suite, and that groceries and things like that will be provided until you get a negative test result. Jerry, window cleaners, vacant land condo hired by unit owners, are they permitted? Not to my knowledge. Also, access roadways for a condo corp are controlled by a separate corporation. Can they deny access to cleaners? Don't deny access, but the window cleaning is not an essential service, and to the best of my knowledge is not allowed to be operating right now. Thank you. Okay, thank you, everyone. 63 minutes. That's a lot of time for me. Keep an eye out for Case Law Corner on Friday. Thank you, everyone, for joining me. I had a lot of fun today. I hope you did too. And stay home, stay safe. And thank you so much for all the great questions. I really appreciate it. Thank you. All right. Signing off for now. Brad Chaplik. Have a nice afternoon, everyone. Bye.